Welcome back, business law students. Today we're going to talk about breach of contracts. What are the remedies? Now, what do I mean by remedies? Well, what do you do when another company has breached the contract with you and your boss comes to you and says, hey, our supplier was supposed to deliver such and such yesterday. They didn't do so. Well, then theoretically, you can bring a lawsuit against them if you don't resolve it outside of court. But what are the damages? All right, let's talk. Let's jump right into the outline. Bear with me. So we're going to talk about the types of damages. When a liquidated damages will be upheld, that's usually in almost all purchase or sale contracts between businesses. In addition to legal damages, what are some equitable or fairness remedies or damages? And what's a waiver of a breach? All right, let's get right after it. So basically, when you hear damages, it simply means the other party did not fulfill their contract obligations and we suffered damages. Let's do an example. You talk your boss into, hey, I found a new supplier. They will send us 1,000 phones for 1,000 blue phones for, $200 per phone. We know we can turn around and sell them for $400. I think it's a good deal. I think technically they're good phones. Then you've got to get them out. You've told all your stores and distribution points, we're going to have this to you by January 1, all these phones. Well, they don't show up. And in fact, they're delayed for 6 months. What do? Well, we, the buying company, and to save your job, frankly, you sue for damages to recover the amount you've lost. What's the amount you've lost? Well, let's start getting into damages. First, one type of damages you could sue for are called compensatory damages to compensate you for your direct costs. All right, let's watch a little video that describes it better than I do. Bear with me.
Compensatory damages. Compensatory damages is an amount of money intended to compensate a plaintiff in a civil lawsuit for what was lost as a result of a legal wrong committed by the defendant. The intention of compensatory damages is to reimburse a plaintiff for out-of-pocket expenses and to make them whole again. An example of compensatory damages may be the amount of money expended on medical bills or lost wages resulting from a car accident caused by a defendant.
Right. So in our scenario, compensatory damages, or for you to be compensated for your loss, would be the $200 per phone that you paid times 1,000 phones because you prepaid for the phones. So if you sued your supplier, that amount would compensate you for the amount you had paid, a compensatory damage. But let's say that you, in turn, since you were going to mark them up to $400, you've lost $200 per phone of profit. In addition to that, you may have harmed your reputation with all your stores in which you distribute, and they may not place future orders on you because of what the vendor did, late supply. So how do I recover not just the amount I gave them, but the extra amount that were a consequence of the breach, your supplier not providing the phones in time, those are called consequential damages. Let's look at that real quickly.
Consequential damages.
Apologize, it takes a moment to do the share function. And again, if anyone has a brilliant way to do it even more quickly, let me know.
Are a crucial concept in contract law, often misunderstood. Consequential damages are a crucial concept in contract law, often misunderstood yet potentially carrying significant financial implications. These damages, also known as special damages, refer to indirect losses arising from a breach of contract or other event. Consequential damages differ from direct damages in that they stem from the broader impact of a breach rather than the immediate loss. While direct damages compensate for the value directly lost due to a breach, consequential damages address the ripple effects that follow. Let's consider some practical examples. Imagine a manufacturer fails to deliver materials on time, causing a contractor to miss deadlines and incur penalties. The direct damages would be the cost of the materials, but the consequential damages could include the penalties and lost future business opportunities for the contractor. Similarly, if a software rollout is delayed, preventing a business from entering a new market, the lost potential revenue would be considered consequential damages. These examples highlight why consequential damages often result in more substantial financial award. They can encompass a wide range of losses, including lost profits, loss of customers, and additional costs due to business interruptions. From a legal standpoint, it's crucial to clearly identify damages as either direct or consequential in breach of contract actions. This distinction can significantly impact the outcome of a case and the damages awarded. To mitigate the risks associated with consequential damages, businesses often include waivers or limitation of liability clauses in their contracts. These clauses can cap financial liability or exclude certain types of damages altogether. However, the enforceability of such clauses can vary depending on local laws and the specific circumstances of each case. It's also important to understand related concepts in damage assessment. Actual damages, also called compensatory damages, reimburse for tangible losses. General damages cover intangible losses like pain and suffering. Punitive damages, on the other hand, are meant to punish egregious behavior and deter similar actions in the future. In conclusion, understanding consequential damages is essential for anyone involved in contract negotiations or dispute resolution. These damages can have far-reaching financial implications, extending well beyond the immediate impact of a breach. By recognizing the distinction between direct and consequential damages and implementing appropriate risk mitigation strategies, businesses can better protect themselves from potentially significant liabilities.
Okay, now you see the distinction between compensatory, you get paid back the $200 per phone that you paid to your supplier, to consequential damages, what resulted as a consequence of their breach in addition to compensatory damages. Now, as a practical matter, you're going to want to consider the relevant contract documents in this context. So, for example, the contracted issue is you probably sent a purchase order to your supplier. We want 1,000 phones at $200 per phone. Now, if they send back exceptions or a counter offer to your purchase order, you will want to make sure that it doesn't have a clause that says no, or that reads no consequential damages. Because if you do, 6 months down the road when they don't deliver them, and you say, oh, boss, don't worry, we can sue them and get our $200 per phone plus our lost reputation or lost profits. But if you have agreed to the supplier's no consequential damages provision, then you're out all that extra money. So again, this is something to add to your knowledge resume, something that someday as you're looking at the sale documents going back and forth, if you see that, you need to point that out and not agree with it. This is going to could be a way to help uh, progress your career because you discovered something that no one else in your department did. All right. These everything I'm teaching you here is not so you become a lawyer. Some of you might, but so that it advances your career because you have this base knowledge that, oh, wait a minute, I remember learning about that business law. That's a red flag. And you look it up again. Okay. All right. Next, we have a different type of damages called punitive damages. All right. Now, I don't like the fact that punitive damages is discussed by the text in a contract damages chapter because it really is a tort law principle. Let's go back and talk about the distinction between a contract and a tort again. All right. You rent a car from Avis. Then I'm walking across the street in a crosswalk. You look down at your phone and run into me. Okay. Well, then you take the car back to Avis damaged and you didn't buy insurance. Well, there's two type of lawsuits or causes of action that might result of that from that. And the first is the rental car company, Avis, could sue you for breach of contract because you agreed to bring the car back in the same condition in which you picked it up. Conversely, I could sue you in a for a tort, negligence, or maybe an intentional tort if you saw me and said, "Oh, I hated that professor. He was so boring and ran right over me." Either way, that is a tort for a violation of a right that I had, not a contract. So, anyway, that's a long way of saying they really shouldn't talk about punitive damage in this chapter, but now since they've introduced it, I'm going to show you. Now in your uh I'll have you watch in the outline. You will see. Let me share the outline. Basically, you'll see this YouTube here and here on punitive damages. And basically, um, punitive damages are basically punishment. So if someone does something very egregious, very wrong, then uh, the court or a jury can assess punitive damages to punish. It's like it's not criminal law, but it's a civil law punishment. For example, this policy holder got hit in a rear end collision, had injuries, blah, 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 and his insurance company just delayed, didn't pay it. And once he took it to trial, the in addition to his compensatory damages, the court awarded 100 million in punitive damages against the insurer to try to deter them from future similar bad behavior. Okay. Now we're going to look at something next category. We're looking at something called nominal damages. All right. Now, nominal damages are minimal. Okay. Nominal damages are, yes, I have a legal right to sue somebody, but the damages really aren't of any consequence. Keep in mind, every time you bring a lawsuit, there are two major things to prove. Number one, the other person's liable. My supplier did not produce the phones. And then number two, I have to prove the amount of damages. Here's my bank statement that showed I paid the $200 per phone. Here's a letter from my supplier saying they're canceling future orders. Here's my accounting records that show I would have made, $100,000 on this and future orders. So the second half of the case we're proving are damages. Now, let's say that you're at the bar with a bunch of friends and you call one of the guys a manho. Well, let's presume he's not, just for this hypothetical. theoretically, he could sue you for defamation, but really, what are his damages? Everybody laughed. So at court, you get sued and you argue, yes, I said it. I admit it's not true, but everyone just laughed. They thought it was offered in humor, not accusatory, and it wasn't put on Instagram or what. I'm over 40, so I said Facebook, Instagram, etc. So really, what damages? Well, in that case, a court can assess what they call nominal damages. Let's look at a video real quick about that. Bear with me. Nominal damages are usually in the amount of, say, $1. Because the court says, yeah, you're right, but it's okay, you weren't harmed. All right, let's share.
By the court because, though the defendant violated the law, that nominal damages, an insignificant sum of money like $1, awarded to the plaintiff by the court because, though the defendant violated the law, that violation did not cause any substantial recoverable harm. One more time. Nominal damages, an insignificant sum of money like $1, awarded to the plaintiff by the court because, though the defendant violated the law, that violation did not cause any substantial recoverable harm. Crescendo's.
All right, let's review quickly. We talked about 4 types of damages. Compensatory, that compensate you for your out-of-pocket, if you will. Consequential, the damages that resulted in addition to your out-of-pocket. 3, punitive damages, punishment, punitive punishment. And number 4, nominal. You really didn't have any significant damages. All right. 2 additional concepts are, and these aren't, the first is not really the type of damages, so I don't like the way the text does this, but in any event, when you are going to sue the supplier that didn't send your phones, you, even though you're suing, you have a duty to mitigate, or in other words, minimize your damages to the best you can. You shouldn't just sit around for 6 months and let's say that in month 3 they say, oh, we're not going to be able to deliver them on time. Well, you should probably start looking for another supplier, and then you won't have as much consequential damages. Because otherwise, once you sue the supplier, they come to court and say, we told them in month 1 we had a delay. They didn't do anything about it. So theoretically, you could have gone to another supplier and only had 1 month of damages instead of 6 months, et cetera, et cetera. So you have a duty to mitigate your damages. Also, there's a thing called liquidated damages. We're going to get into that. All right, let's first look at a video about mitigation of damages and the duty you have to mitigate damages.
What is mitigation of damages? Imagine you are involved in a situation where someone has caused you harm or loss. You might think that you can simply claim the total amount of damages without taking any action to reduce them. However, there is a legal principle that requires you to take reasonable steps to minimize your losses. This principle is known as the mitigation of damages. Mitigation of damages is a legal doctrine that applies in various types of cases, including contract disputes and tort claims. The idea is that a party who has suffered harm cannot simply sit back and wait for compensation. They must actively seek to lessen the impact of that harm. This means taking reasonable actions to reduce the extent of the damages incurred. For example, if someone breaches a contract and you suffer financial losses as a result, you are expected to take steps to find a new supplier or service provider to minimize your losses. If you fail to do so, the amount you can claim in damages may be reduced because you did not take reasonable steps to mitigate those damages. The burden of proof typically lies with the party who caused the harm to demonstrate that the injured party did not take appropriate measures to mitigate their losses. Courts will often look at what a reasonable person would have done in a similar situation to determine if the mitigation efforts were adequate. In summary, mitigation of damages is about taking responsible actions to lessen the impact of harm or loss. It is an important concept in the legal field that encourages individuals and businesses to act proactively in minimizing their damages. Understanding this principle can help you navigate legal situations more effectively and ensure that you are not left with unnecessary losses.
Okay, so you understand about your duty of mitigation of damages. Now, there is a concept called basically liquidated damages. And you'll see in the outline, bear with me. Oops, apologize. And I'll have you on your own watch this video. But basically, I mentioned in your the supplier you're using for your phones, in your purchase order that you send to them, which is a contract, you likely will have a provision that says, look, it's so hard to calculate how much we would lose in damages, consequential damages, that we're going to agree that for every, in this instance, 0.5% per week, up to 5%. So basically, theoretically, you've agreed that this is the amount of damages in the case they're late. So up to 5%. Even if you have to cancel it after that. So they would owe you 5% of your purchase price in addition to reimbursing your purchase price. That's known as a liquidated damages clause. Courts will often enforce liquidated damages clause as long as they are not, the amount is reasonable and it's not really a penalty, punitive. So for example, if this clause that you're looking at said you have to pay 50% per week of delay, that is not a reasonable amount per se, and a court would probably not enforce it. All right, I'll let you read through that. Again, the answer is in your textbook, but it just kind of gives you a practical application of, do I think something is a valid liquidated damages? All right, now, let's say aside from damages, you just say, okay, judge, this is what I'm seeking in my contract breach when my phone supplier breached the contract. All right, first, rescission. Okay, judge, we're just asking that we set it aside. We go right back where we were. Let's say, for example, we haven't paid for the phones yet. They didn't deliver them on time, and we seek rescission. Just get us back where we started. We don't pay, they don't deliver the phones. All right. Restitution. Let's say we did pay. Well, then we'd ask for restitution because we paid, they never delivered. So restore or give us restitution for the amount we paid out. These are really called causes of action. You might recall that I told you when you sue somebody, you have to put it in a little box of what it's called. You don't say, I'm suing you. You'd say, I'm suing you for restitution, and this is what I'm proving. Specific performance, that's when you want the judge enforce the contract, make them perform what they promised. I paid someone who's really qualified painter $1,000 to paint my house, gave them the money, they didn't do it. I don't want some other painting company because they're really good and they do a special finish or something. You can ask the judge to order them to perform the contract, and that is called specific performance. Also, theoretically, a judge can look um, at what's called reformation, and you left out some key terms or something was vague or et cetera, et cetera. Theoretically, in certain instances, a judge can actually get into the contract and reform it so it is fair or what he thinks the party's intents were. There's a review. I'll let you look that on your own, but that just sets out the types of damages and the types of causes of action or remedies you can seek. There's also, I'm going to let you watch this on your own, but there's also a concept called quasi contract. So let's say, even if we didn't have a contract, in some instances, it is fair for one to be reimbursed for what they did. And so it's equitable, it's fair. And that's a quasi contract remedy. So please watch that video because it describes it very well. All right, that is it for this week. Thank you for your attention, and I'll see you at the next chapter.